you so much for being here today. My name is Devorah Margolin. I'm a Senior Research Fellow here at the Department of Extremism. And today we're going to be having our second event on the legal perspectives of online terrorism, which is part of a bigger series that we've done with 13 papers. I highly recommend you check them out. We have a few, Andrew put some of them somewhere around the room if you haven't had a chance to look at them. We have some really interesting papers talking about the issues regulating online extremism right now. It's very loud, sorry. I'd like you to help me welcome today Professor J.D. Maddox, who is an adjunct professor of national security studies at George Mason University's Department of Information Sciences and Technology. He recently served as the Director of Analytics at the Interagency Global Engagement Center and has led counter-terrorism activities for the Central Intelligence Agency, Department of Defense, National Nuclear Security Administration, Department of Homeland Security, and is currently a consultant with the State Department. I'd also like you to help me welcome Professor Anne-Marie Bridey, who is a professor of law at the University of Idaho, an affiliate of the Yale School of Information and Society Project, as well as an affiliate scholar at Stanford CIS.
You should turn off one of the two microphones.
Turn off or up?
Turn off one of them.
Let's try this.
Well,
I'm going to stop talking now, so let's leave yours on since you're speaking first, and I will turn mine off. And I'd like to hand over the floor to Professor Bridey.
Thanks. So I was asked to write about Section 230 of the Communications Decency Act and how that helps or hurts when it comes to regulating extremist content online. So I'll just start by saying that I think we need to be sophisticated when we think about the relationship between real-world violence and extremist content online, right? Radicalization, I think, is complicated. At the same time, though, we need to, and I think we all do recognize, that extremists have learned to leverage the architecture of social media platforms to amplify and spread hate and propaganda. JD has made some important points. He makes the very important point, I think, in his article that we shouldn't and can't rely exclusively on content moderation to deal with the spread of online propaganda and disinformation. But I'm here to say that I think content moderation can help a lot. And Section 230 of the Communications Decency Act is what makes content moderation possible on the large social media platforms that extremists have been exploiting. So in particular, Facebook, Twitter, and YouTube, what we call the big three of the social media platforms. So there's been a lot of misinformation about Section 230 circulating in the media in recent months. I don't know how much you guys follow sort of the inside the beltway stuff on Section 230, and Representative Hawley and Senator Cruz have sort of set their sights on Section 230 as though it is, something that gives a free pass to these giant social media companies that are being irresponsible. I have, I think, a sort of sunnier view of Section 230 that I would like to share with you today. So I'd like to just talk a little bit in some broad strokes about what Section 230 does and doesn't do. What Section 230 does, I think, two very important things. The first thing it does is provide immunity to platforms from legal liability for illegal speech posted by their users, right? So the typical situation here is a user sees on Facebook some statement that someone has posted that he or she thinks is defamatory. They file a lawsuit against Facebook. Facebook will file a motion to dismiss that lawsuit. It will raise Section 230 as a defense. And pretty much cleanly they will get out of that litigation, right? Because the idea behind Section 230 is we should hold speakers liable for the illegality of their own speech, and we should sort of take the intermediary out of that dispute. The second thing that it allows platforms to do is acting in good faith to block or remove content that they consider to be objectionable, whether or not that content is protected by the First Amendment. In other words, Section 230 lets platforms block or remove harmful content and extremist speech, including hate speech and targeted harassment, that Congress is actually constitutionally constrained from regulating. Much of the extremist speech that foreign governments are now requiring platforms to remove, and I think maybe JD will talk about this, or we can talk about it later in the Q&A, is actually First Amendment protected speech in the United States. And it's true that incitement and true threats are not protected speech, and I think we would think of a lot of the extremist speech that we're talking about today as incitement to violence. But it's important to note that U.S. courts have defined true threats and incitement very narrowly. So if you believe that platforms should be empowered to remove hate speech and vilest extremist content without facing protracted lawsuits from angry Nazis and 8chan edgelords, then Section 230, I think, is your friend. So what Section 230 doesn't do? Section 230 doesn't give platforms blanket legal immunity from all civil and criminal claims. You'll hear people talk about it as a sweeping immunity, and it is a very broad immunity, but it is not an absolute one. So I talk in my paper about a range of express limits on Section 230 immunity. For example, Section 230 doesn't immunize platforms from claims for intellectual property infringement, for privacy violation, for violations of federal criminal law. Since 2018, for certain civil and criminal claims relating to sex trafficking and prostitution. So it's not by any means a blanket immunity. It also doesn't give platforms illegal immunity from claims related to illegal content that their own employees create or develop. Right? So the idea is we're going to immunize you for content that is your user's content, but you will still be responsible for any illegal content that you materially contribute to creating or developing. It also doesn't require platforms to operate as neutral public forums for all First Amendment protected speech. And I think a lot of the rhetoric that we hear these days inside the Beltway is this idea that the trade-off was that you have to act as a neutral public forum if you want the immunity, and if you're going to be moderating speech, then you can't have the immunity. I do think most people agree that platforms can and have to do better than they have when it comes to defining and managing objectionable speech. I think they also have to do better at communicating policies and policy-based decisions to their users and to the public. With that said, I think that gutting Section 230 to punish Facebook, YouTube, and Twitter for not doing a better job than they have done would be counterproductive and would have negative effects for the broader internet ecosystem and also for the public's interest in controlling the spread of extremism and disinformation. Thanks.
Thank you. And I'd like to now hand over the floor to Professor Maddox. No, they're not turning off. We have a small technical issue. We're aware. I've asked them to send somebody up, so I apologize for the ringing. Hopefully we I might just move this one over to the side to help.
All right. Good morning, everybody. I'm J.D. Maddox. Thank you for the intro. I'd like to emphasize that I'm a practitioner in this space. I've focused on the problems of disinformation and propaganda with all those interagency elements that were mentioned earlier. And I'm currently an independent consultant to the State Department, where I continue to focus on that for the Global Engagement Center. And I focus on it as well as an adjunct professor at George Mason University. So I take this very seriously. One of the things that bothers me about this issue the most is that there's currently a narrative, at least in the media, of hopelessness against this problem of disinformation, propaganda, and extremist use of these tools online. So I'm hoping that my dialogue today will at least edge us forward against that narrative. And in my paper, I focused on how we came to rely so much on content moderation against these problems. I'd like to talk a little bit about how we got there. We've been cut off.
Is that
Did it turn on? I'm just trying to reduce the reverb on it. You want to test it real quick?
If you want to just leave one of them on.
Yeah, that's fine.
Sorry.
It's probably good.
Can't tell if it's two or three.
All three are on right now.
Yeah, so they're all controlled centrally, so I would just suggest that maybe two of you share one of these.
That's fine. We can just turn off that one, I guess. Perfect.
Cool. Great. Thank you.
Is that
All
okay?
right. Everybody hear me? Just hang on? Okay.
Perfect.
So you can hear me anyway, right?
Thank you.
So one of the most consequential events in modern information warfare occurred on February 3rd, 2015. The winter before then, we were watching intently as the terrorist group ISIS was having significant battlefield successes in Iraq and Syria, and really significant successes online, boosting their image and gaining some notable supporters online. In the winter, they had about 46,000 mostly uncontested ISIS-controlled accounts on Twitter, and each of those accounts had about 1,000 supporters. Those stats are actually coming from GWU, which I think is great. Keep going.
Thank you.
So that winter, we saw it as a Jordanian pilot named Captain Al-Qasasbeh crashed his F-16 jet in Iraq, and ISIS picked him up. About a month later, they developed a video, highly theatrical video, where essentially they set him on fire in a cage while ISIS in uniform were arrayed behind him watching, and made the claim, of course, that they were remaining and expanding, and that they were taking justice against their aggressors. This was in the wake of the Charlie Hebdo attack in Paris, and it really hyper-focused us on the problem of ISIS's essentially control of social media as they were developing their so-called caliphate. And our effort at that point was various, but one of them was to pressure social media industry to take action against that content online. And by October of 2015, I think that was really the peak moment for our pressure against the social media industry during a global coalition against ISIL Communications Working Group in London, where we essentially asked them publicly and privately to get rid of a lot of that content. So the average tweets per day per ISIS account during the period peaked at about 14.5 per day in June and dropped to about 5.5 per day in October. That was considered a significant reduction in the amount of content that ISIS was able to produce. But it did not, of course, eliminate their activities entirely. Twitter reported suspending about 1,200,000 accounts between 2015 and 2018 for violations related to the promotion of terrorism. And since then, state networks such as Russian, Chinese disinformation networks have actually seemed to displace ISIS in terms of the amount of content that they are pushing online. For example, in 2017, Russia's Internet Research Agency posted about 6,000 Instagram posts per month, about 4,000 Facebook posts per month, and over 59,000 Twitter posts per month. And about 30 million users interacted with IRA, or Internet Research Agency, content on Facebook and Instagram in 2015 to 2017. So this issue has really exploded. And the community has really placed a lot of emphasis on the use of content moderation as a almost singular solution. In July 2018, Twitter released a suspended data set of almost 3 million tweets from almost 3,000 handles run by IRA from February 2012 to May 2018, certainly affecting their operations. So content moderation is clearly very useful, but what I would like to focus on are other solutions that I think would be even more successful against ISIS and other terrorist groups in combination with content moderation. I think these solutions simply don't get enough attention for a number of reasons. One, they're simply misunderstood or not known at all. We can go into a little bit more detail about that afterwards. So there were 7 different categories of technology that I think are potentially useful against this problem. First, content validation. Private industry has essentially progressed in developing blockchain-enabled video and content validation companies like TruePic and Amber Video have successfully developed systems that allow you on your smartphone to take a video, and then that video gets stored to the blockchain with a unique fingerprint. And then if you then share that video out to other users, that it's essentially testimony. You cannot meddle with the file itself without the rest of the group knowing that it's been meddled with. The second category, de-anonymized social media accounts. Most of the Russian disinformation distributed during the 2016 US elections was distributed by fake name accounts, and I think de-anonymization can help. Facebook and other social media platforms have played with this, offering check marks next to accounts that have been verified. That could potentially be used at a broader scale. Third category, automated website ratings. Companies such as the Global Disinformation Index have progressed in identifying the platforms, the websites that are essentially pushing disinformation and misinformation online. And those lists that GDI and other organizations are making are potentially useful to the social media platforms themselves, but also to advertisers to make sure that their content isn't going to the wrong place. It's also useful to help the average information consumer to avoid those sites. Those website ratings have been called blacklists, but I think that they've actually been used for almost a decade now to help the ad tech or the advertising industry with placing their ads. So anybody who has placed an ad online is already using a blacklist. Next category is crowdsourced information verification. This helps overcome essentially the tyranny of one-sided presentations by providing a forum for critical meta conversations literally atop the content online. Services like web annotation allow you to actually have an independent conversation over something like an al-Baghdadi video so that you can converse about the reality of what he's saying in real time. Next category is online advertisement and content attribution, such as paid-for buy statements on Facebook and overlay ads on YouTube. They progressed with these tools during recent EU elections, and they seem to have some reliability. Yellow alerts. This would be the use of social listening tools to find when a disinformation or misinformation campaign is kicking off, and then alert social media users to it and make sure that they're aware of it. And then finally, tech-enabled media literacy training, especially games and training that can strengthen information consumers' ability to distinguish between fact and fiction, such as bad news, fake news, the game, fakey. These are all useful for training people in discerning between fact and fiction. And then finally, I think we're at the beginning of a push for a stronger regulation of internet content, and that's manifesting itself in new legislation such as Germany's 2018 Act Against Incitement to Hatred, Singapore's bill enabling removal of false content, and of course the recent Christchurch call, which asks for or demands voluntary content moderation by the social media platforms within 24 hours, which really directly conflicts with the U.S.'s position against direct censorship of online content. Thank you.
Thanks so much. Before I open the floor to questions, I'm going to abuse my powers as moderator. And first and foremost, if you haven't yet read these papers, we have Professor Bridey's paper, Leveraging CDA 230 to Counter Online Extremism, and Professor Maddox's paper, Lessons from the Information War, Applying Effective Technological Solutions to the Problem of Online Disinformation and Propaganda. So please do check those out. I really enjoyed reading both of your papers. We chatted a bit before, but I wanted to kind of dig in a little bit. Professor Maddox, in your paper, you provide a lot of options. You talk about from crowdsourcing to video games. And I guess my question for you is, these options are all very interesting, but is there one specific option or a combination of options that you think would be the most successful?
Well, I think the most recent literature from the psychology community indicates that there's essentially two camps of thinking on this issue, on our vulnerability to disinformation and propaganda. One is that we're just fundamentally intellectually lazy, and we don't want to take the extra step to understand what the information that we're consuming. The other is that we're in that so-called bubble, and that we're unable to get out of it and find additional information. I think that argument is useful for kind of pushing us forward to useful tools against this. But they're both essentially saying the same thing, that we need to make people more critical of the information that they're consuming. So I think that tools like content moderation are essential to this fight, but they're not getting the average information consumer to the point where they are defending themselves against disinformation and propaganda. They're essentially putting it all on the social media platforms to referee this information environment. So other tools, I think, are absolutely essential, such as media literacy training through games and other resources, I think are very important. I also think that content validation is key, and being able to have conversations atop disinformation and propaganda campaigns is very important to flag that for the average information consumer.
Thank you. And Professor Bridey, we had talked a bit about this before also, but the new EU legislation, some cases 24 hours, some cases within an hour, information needs to come down. And then you have on the other side the US case and the freedom of speech and the leaving it to the media companies themselves to kind of self-moderate, even if they ask for knowing what they won't get, which is moderation from the government. Which do you see as more successful? Do you see as them both failures, both successes, and how they differ?
So that's a good question. So I think that, when we're talking about recent legislation in the EU, so we talked about the Net Enforcement Act, which is German, the NetzDG law, which says basically content that is clearly illegal, good luck figuring that out, has to come down within, is it 24 hours, and content that's not clearly illegal has to come down within 7 days. And the fine, I think, is 5 million euros if you don't get it down. So these are really significant financial penalties. I think when you have those kinds of tight turnarounds and lack of clarity about what exactly is clearly illegal speech, what's going to happen is the platforms are going to act rationally and they're going to overblock. Right? They're just going to not err on the side of getting a $5 million fine. And so in all of this, I think one of the things that we haven't talked about that's important for us to emphasize, and this gets to questions about the First Amendment, is what about freedom of expression? Like, we can all agree that we want the bad stuff to come down, right? But we don't all agree on what the bad stuff is, which is one problem. And then the second problem is that in the U.S. anyway, a lot of the bad stuff is actually First Amendment protected speech. Platforms, as private actors, are not state actors, so they have freedom to limit that kind of speech in their community guidelines if they want. There are, I think, problems when the government begins to apply a lot of pressure on platforms to moderate certain kinds of content out and take certain kinds of action, because I think there we run the risk of laundering state action through private action, right? We don't necessarily want the government to be putting a lot of pressure on private actors to determine what is and what is not acceptable speech. It's a kind of end run around the First Amendment that should make us anxious, right? Like, it's not a bad thing necessarily to have public-private cooperation in this space, but I also think that we need to, there are reasons why the Bill of Rights puts limits on state power, and I think we need to be careful of having that state power sort of laundered through private actors without adequate due process. So I think that, we can credit the EU for taking action, right? We have also the new terrorism content regulation, which is, I think, not quite in effect yet. It's still being sort of hammered out in terms of its details, but we do know, I think, what the structure is going to look like, and it's going to be another one of these, you have to get it down within 24 hours. Part of the problem, again, with these things is how do we define what counts as terrorist content? Obviously, we don't want content that is, directly inciting violence, right? But where do you draw the line between direct incitement and just sort of enthusiastic belief, right? And so, you know, in the U.S., we say that as speech gets closer to conduct, you know, we can have it regulated a little bit more freely, right? But it's hard to tell where speech is kind of bleeding into the line so that it's going to cross the line into some kind of illegal, like, real-world harm. And so I think that there are some real kind of constitutional thickets for us to navigate in the U.S. In a lot of ways, because the major platforms are private actors, we tend to not worry about them because they have such a free hand, but I think we should be worried about them. And, you know, the civil libertarians among us, I think, have to push back a little bit against the kind of just sort of blanket pressure to just get all of this content down. Because there is baby in that bathwater, and there is, you know, there's a lot of protected expression, I think, that's ending up kind of on the cutting room floor, to use a film metaphor, right? And so, you know, it's great when we say, wow, Twitter took down like 100,000 accounts, right? Do we really think all of those 100,000 accounts were sort of ISIS linked? How many of those were not, right? How many of those were marginal, and did the people who thought that they were unfairly targeted in that purge have recourse to try to say, no, I think that you've made a mistake, right? That my account shouldn't have been swept up in this. And so on the one hand, it's great when we can say, wow, they just took out 20,000 accounts overnight. And on the other hand, we should say, wait, they just took out 20,000 accounts overnight, right? And so I just think that we need to use care. We need to ask social media platforms to be accountable for what they take down, and we need to ask them to healthily resist, I think, some forms of government pressure, and for them to push back against the government, even though we're all sort of pushing toward the same goal, of course, of protecting the integrity of our democracy, right, and not allowing extremists to kind of silence other people on social media who should also have a voice.
I have a lot more questions, but I'd like to open the floor to the audience if anybody has questions here, and if not, I can always keep talking. Anyone? Yes, sir.
I'm Mike Nelson. I've worked at IBM and Microsoft and Cloudflare, and I'm now affiliated with Georgetown and Yale University. One of the problems is that policymakers just see the internet, and they don't distinguish between the social media platforms, the ISPs, the companies that provide security, companies that provide domain names. I'm wondering if you're worried about some of the initiatives that are putting pressure on the people who are actually running the infrastructure of the internet, moving the bits, providing the security, in some cases moving trillions of bits a second. There are fewer of them, so they're an obvious choke point. But it's very hard to see how they could do the kind of fine-grained content moderation that a social media company would do. And they don't have permission from their customers to do it, whereas Facebook is claiming it's providing a safe platform. Verizon is just in the business of moving bits and isn't supposed to be filtering things, but they're under pressure to do that, and companies are saying, okay, we're not going to serve that company, we're not going to serve that company. Do you think we can find a way to get the right people solving this problem rather than trying to force everybody who runs the internet to somehow win?
Yeah, so this is the Matthew Prince Daily Stormer question, right? So I don't know how many of you follow this, but Matthew Prince is the CEO of Cloudflare. Cloudflare is a kind of infrastructure service that provides DDoS protection and proxy services for websites. So, and some huge amount of websites on the web are actually protected by Cloudflare's services, right? So they are an incredibly important service that sits kind of between the content layer and the network layer on the internet, right? And the question is, how far down the protocol stack do we want to go when it comes to content moderation, right? And the sort of the traditional way we regulated was always to say that services like Verizon were the pipes and that they should just be passing bits around and shouldn't be moderating content. But services that sit at the application layer of the internet and the content layer should be moderating content because they're closest to the content, they're closest to users. I think that that's a principle that we should respect. I think it has been kind of turned upside down, and we are seeing all kinds of pressure on these kind of infrastructure services like Cloudflare, and also increasingly domain registrars and registry operators. I think that we need to be very, very careful, and that we should really try to keep content moderation close to the surface of the web, just on principle. But I think that that's, I think that those days are gone when we can have that. And in part, they're gone because we just saw the repeal of net neutrality, right? Like one of the core ideas was that, we would have net neutrality at the network layer. But now that the FCC has, successfully sort of rolled back those rules, it's okay for Verizon now to discriminate based on the traffic that it carries. And so, so we've seen chinks in that sort of, in that original way of thinking about content moderation. But I think it is important to think not only about what content is being moderated, but who's moderating it. And I think that there are some services that maybe we should say should function as common carriers, right? And it's just like, you just have to carry all lawful speech, right?
But it's really the difference between holding a newspaper responsible for a libelous comment or indecent material and holding the ink company and the paper company and the automobile company that makes the trucks that deliver the newspaper. It's just a totally different kind of...
Right.
It's an ecosystem, and you can't hold the whole ecosystem responsible.
Yeah, I mean, not to sort of push my own content on you, but I have a paper that talks about this at length from 2016 or something called Remediating Social Media, a layer-conscious approach that talks about, we need to think about the layers at which we're regulating content, and there's a reason why in the early days of the internet we devised policies that said the network layer stays open, subject to common carrier-like regulations that we would see for telephony, right? But that the content layer is one where we moderate content, right? And Section 230 is about that, right? And also the DMCA for copyright is similar, right? These are intermediary liability sort of safe harbors that you get at the application layer that we don't need at the network layer because that's not where we regulate content.
I will tweet that URL right now.
Excellent. Do you have any other questions? Yes.
So I'm Sherry Clark from the State Department, colleague here with JD in the Counter-Terrorism Bureau, and so we work in the policy space on these issues. And I will, I have one question for JD. I would just like to ask, as has been commented, the EU legislation, the NETS-DG, and some other laws have highlighted our apparently increasing differences on policy in the U.S. government because of the First Amendment primarily, and some of our partners who are increasingly pressuring companies. And you're right, it is absolutely true that a lot of policymakers don't understand the difference in even the internet and social media platforms. They tend to, we see resolutions at the UN that equate the two or talk only about social media, and then there's the whole ecosystem, which is not even a thought. So one of the things we've been trying to do is educate policymakers, which is a big challenge. But anyway, so I just wanted to ask JB to clarify when you said that the GEC pressured with the Global Coalition. I think you meant the communication cell, social media companies to take down content. If you could kind of clarify that, because our experience in working even with our close allies with whom we share common values has been that we are sort of the outlier, as our Department of Justice has evaluated the First Amendment to say that we are not to in any way coerce companies or pressure them. That I think probably you didn't mean that, but we, even as part of the coalition, can only go so far in encouraging companies to expand and enforce their own terms of service, that sort of thing. We also have not been in favor of basically putting all the onus on the social media companies and the internet companies. Governments have a role too. There are other ways, counting by extremism, other tools that we want to focus on. So I just wanted to ask JD to kind of talk about that a little bit more, and the sort of lines that are being drawn about what we as U.S. government are doing and how we work with other governments. It's been quite difficult in the policy space and even in the communications space. But if you could clarify that, I would appreciate it.
Sure. Yeah. So we certainly weren't arm wrestling with Mark Zuckerberg throughout 2015, trying to get him to take down content. It really was an emphasis showing them what was online, what the intensity of ISIS's effort and what they were able to do, how they were coalescing an online presence, and making sure that the social media platforms were aware of that and were able to take action against it. And we were working with them to try to understand, what are those lanes in the road? How what's the government's role? What is the social media platform role? And how do we do that in a lawful, ethical way? I think that back to the previous question and to this question, these tools, content moderation and others, are most successful when they're used on the supply side. Once the information reaches the consumer, then the information is essentially viral no matter what. There's no getting rid of it. It continues to move through the information environment. If we can potentially catch information on the supply side before it's disseminated, then we're in a much better space. A lot of the tools, and Sherry, you're right, we're looking for other tools, and the 7 categories that I've tried to detail are some of those. Again, they're attempting to focus on the supply side, attempting to try to stop the information before it reaches the information consumer to help them defend themselves. And I want to emphasize that the government certainly isn't in this position where we're pushing for specific content moderation. We're again working with these companies to try to find the right methodologies.
Thank you.
Hi, for Anne Marie. You read the New York Times story about the president of Brazil using a disinformation campaign to terrorize professors. He was spreading apparently rumors that certain professors were engaged in gay conversion programs, and that was causing the professors to receive death threats. And I'm thinking the closest analogy here probably is the Pizzagate affair, where someone was alleged to have been storing children in the basement of their pizza parlor, and that caused them to receive death threats. And I'm wondering what would be the problem with exposing some of these app providers, social media providers, to liability in the event that they don't take down content upon a request from, say, a professor who's received the first death threat because of a misinformation campaign. And related question is, do you think that as an economist, what I'm worried about is whether these social media platforms have the right incentives to take down content that is resulting in threats that are aimed at, say, professors? Why would they internalize the cost that the professor bears, especially if they can monetize some traffic that's associated with the controversy that erupts?
Well, I mean, this is, I think, fundamentally a problem of scale. And I think one of the reasons that the immunity is in place and is as broad as it is for Section 230 is that these requests, if it were just one professor making a request, right, and somebody could at Facebook sit down and say, does this seem like a reasonable request? Is this really a defamatory statement? Is this really a threat that we should believe? That might be realistic, but these platforms have millions and billions of users. They're getting hundreds of thousands of these requests a day, right? How do they have, or how should we expect them to have the expertise to investigate all of these complaints and to try to figure out whether they really are legitimate complaints or not, right? And so I think that, scale prohibits, the idea was we want to take the platforms out of the middle of this, right? We want to make it possible for the person who is engaging in illegal speech to have court action against them so that they can be liable for the speech, right? So it's a question of, do we think it's reasonable as a matter of policy to make intermediaries liable for the speech of others, right? And, reasonable people can disagree about this. But I think that most platforms could not afford to operate if they had to assume that liability. I think they wouldn't get funding. I think they just operationally couldn't do it. We've reached a point now where we have mega platforms that are so wealthy and so concentrated that they probably could afford to assume some of this liability. But the problem with altering the scope of the safe harbors is that the safe harbors apply globally across the whole network. So to your website, if you have one, or your blog, if you have one, to the New York Times and its comments section, as well as to Facebook and YouTube and Twitter, right? And so I think, when we talk about sort of trying to adjust incentives, we want to think about whose incentives we want to adjust and be aware that when we're, altering the scope of generally applicable law, we're doing that across the whole surface of the internet, right? And not just for the big platforms that we think are the most problematic. I do think that, I would say the 2016 presidential election was kind of a watershed, and that was a wake-up call for most of the social media platforms, the giants, and that they have begun actually to sort of get their houses in order, even with 230 in place, right? So I think that they are doing a better job than they did before. I think part of the reason was, the U.S. is a very sort of liberal speech environment and has been, right? We have the First Amendment for the longest time. Silicon Valley grew up and these companies grew up with very libertarian speech values, right? And the idea was, if it's not illegal, no harm, no foul. And I think that social norms have rightfully shifted away from that place. And I think that it just took the large companies a while to recognize that the social norms had shifted, and along with those shifting norms, their obligations to their users have shifted, so that they do have an obligation to be better about trying to take down hate speech and harassing speech and speech, that I call in the article lawful but awful. And so I do believe still strongly in maintaining these safe harbors. I think that, they are a good way to make it possible for us to have these massively participatory platforms for the public. In some ways, the platforms are making a lot of money, but they're also providing sort of forums that never existed before for human communication and expression. And I think that we sometimes, it's become such a hellscape lately in terms of like the social media environment that we forget about all the good things that social media platforms have brought culturally. And I try to keep those in mind. So I don't know, probably doesn't satisfactorily answer your question, but I tried.
The question in the way back. Yes, sir.
Yeah. So my question is kind of on the research front for Professor Brady. In your earlier comments, you were talking about the false positive problem. So there are a bunch of account takedowns. The issue you're concerned about there is that we've accidentally, included too many things that shouldn't be there because it's a violation of free speech. But then in the comment you just made, it was more about false negatives because of the problem of scale. So I'm wondering if you could point us to the kind of systematic research that works across platforms to tell us the facts of the matter about takedowns. So how do account takedowns work on platforms other than Facebook? Even Facebook's rather complicated. Account takedowns are rare in terms of the expensive content moderation actions that can be taken. So it's more typical, in my understanding, for offending content to be simply removed or for the account to be closed for a temporary period. To actually have it removed, it has to be extreme violations. That's my understanding. But I would love to get your
Probably both, right? Like, I don't think we have to choose between they're doing, like, I think sometimes they're doing too much and sometimes they're not doing enough. Like, it's not like there are false positives and then there are, there are only false positives or only false negatives. I think it's always a mixed bag, and that it's both over-inclusive and under-inclusive. Increasingly, platforms have transparency reports that you can look at. It has been very hard for researchers to get data from platforms about this stuff. I don't do empirical work, so I don't, like quantitative empirical work, so I don't really know. But I operate in the field and rely on quantitative work myself, and I know that it has been very hard to get this information. I think the platforms are trying to open up about it, but they're also, I think, a little bit afraid to open up about it because they have such a giant target on their backs right now. But the transparency reports, I think, are the first place to look. Google was sort of out in front with transparency reports, but now I think they are much more common. And in fact, some of the legislation in the EU now is requiring transparency reports and auditing of practices. And so, we will see there should be some data coming out of those audits once those laws have taken effect. But the place to start is with transparency reports, which will detail all of the takedowns. Like, right, these are the numbers of requests that we got from governments, right? These are the requests that we got from private citizens. These are the requests that we removed for copyright violations. These are the hate speech requests. But there are a lot of people, doing work in this field now. And like I said, they're having a hard time, I think, getting a hand on data, but I think that some of the platforms are opening up. Like, I recently saw that Facebook had actually promised to partner with some researchers, and they have not been happy because apparently what was promised was not delivered to them. And so I don't know what the negotiations are over trying to get that data, but...
I'm going to take two questions. First you, and then you. Yes.
Hi. Brian Marks at the National Counter-Terrorism Center, actually working on policy. One of the questions that I had is about policymakers that I've spoken to and others. They fear of sort of a balkanized internet, where we have incredibly different rules going across country to country, different solutions. We've had some countries trying to go all the way up to the DNS level to try and say that they want to be able to completely wipe the site out in that sense. All the way down to differentiations between what they are putting out as far as the levels of what content should be taken down, how quickly it should be taken down, what this might do for not only companies but also government efforts. Because Homeland Security, you were talking about where we might have a very different playing field, where we often thought of the internet as somewhat of a level playing field with some variations, in some countries more so than others, but actually seeing real differences in what users in different countries will have access to because of the upcoming policies.
I think we need to admit the ugliness of what we're getting into now. Content moderation is kind of presented as this clean effort where a few social media platforms are able to do this at scale. But the question already came up. What are the other platforms doing? How are they doing it? Some are not doing it. Some are secure platforms that will never do it. So content moderation, again, is not a cure-all for this, and policymakers should expect some fearful consequences of future technological applications in this area.
One final question here in the back. Yes.
Thanks. Give me the last word. My question for Professor Maddox. The solutions have outlined focus on, they assume that it's going to be a problem, disinformation, and focus on mitigating them to some extent. But they're not really targeting the source of many of these campaigns. So I was wondering, drawing from your experience working in the international domain, if you had any thoughts on international mutual legal assistance treaties, and now the Cloud Act coming in, those are ways to rethink mutual legal assistance, but the Cloud Act only targets serious crime. So was there an opportunity to address disinformation through the Cloud Act, and are there ways we to rethink mutual legal assistance to better target the source of this problem, not mitigate its effects?
So the paper that I wrote was focused really on defensive solutions to disinformation and propaganda, especially coming from extremist organizations. And so you're right that these technologies are useful for the individual information consumer to defend him or herself against disinformation as they're encountering it on the web. And so I did not go into at all, sort of the opportunities to aggressively, offensively go after disinformation and propaganda coming from terrorist groups. And I have not given enough thought to the specific issue that you're asking about.
Thank you all so much, and please join me in giving a warm thank you to our wonderful authors and speakers.